I always wanted to serve on a jury.
I'm really super excited.
I'm really super excited to have you, so I really appreciate you having me. I'm
creating this whole trial, there.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
Every time we run into a bar, you should reach for it.
And then I just looked to the jury, and it's sort of like,
I was in the eye of the storm. You guys were watching. You guys were watching.
Come pop in, say hey.
You are a ray of sunshine. And I love what you've done with your YouTube channel.
Hey y'all, good morning. Hey, I am finishing up doing some work here. So, but I went early a little bit live so y'all I'm just going to play this week's court report episode so y'all can hear it. Because I know we had talked about how I had started doing this, but I think a lot of you hadn't listened to it yet or didn't know what it was. So it's like a 24-minute episode. It's like half, most of them are between like 20 to 30 minutes. So they're shorter than my regular podcast episodes, but it's just kind of like the weekly updates of all the stuff. So I'm going to play that while I'm working, and then we will get started right after that. So I'm going to hit play, and then I'm going to be here working, but you still get Lucy too. Case out of Ohio that's already being called the House of Horrors. A shocking twist involving an anti-vaccine activist whose 18-month-old twins died last year. A high-profile murder trial gets underway in New Mexico, plus the latest developments in the Barry Morphew case, Karen Reed, and more. This is the 13th Juror Podcast, where we explore the trials, investigations, and true crime stories that everyone is talking about. I'm your host, Brandy Churchwell. And this is Court Report, your weekly roundup of the biggest courtroom headlines, breaking stories, and the legal developments shaping the nation's most talked about cases. Before we jump into this week's episode, I do want to acknowledge what is probably the biggest courtroom headline of the week, the Tyler Robinson case. Now, if you're not familiar with it, Tyler Robinson is accused of fatally shooting Charlie Kirk, the conservative political activist and the founder of Turning Point USA. This was during an event at Utah Valley University last September. Now, prosecutors have charged Robinson with aggravated murder and are seeking the death penalty. Since the shooting, the case has drawn national attention and become one of the most closely watched criminal cases in the country, with intense media coverage and packed courtrooms throughout this week's preliminary hearing. More on that coming. Now, I know that so many of you have been following every minute of that hearing with me on my YouTube channel, and there is simply too much to unpack in just a few minutes here. So instead, I'm dedicating an entire episode to it where we will walk through the testimony, the evidence, the legal arguments from both sides, and what it could all mean moving forward. And some bombshell court moments too. Now, that full breakdown will be released tomorrow morning, so be sure to keep an eye out for it. But this week wasn't just about Tyler Robinson. We've also had major developments in several other cases that we're following. So let's get you caught up. First, a quick update on the Carmelo Anthony case, since we just covered it in a full episode. Now, if you missed it, Carmelo was found guilty in June in the fatal stabbing of 17-year-old Austin Metcalf during a confrontation at a Texas high school track meet. Now, Carmelo's new legal team is asking the judge to throw out that guilty verdict and is also requesting that Judge John Roach be removed from handling any post-trial proceedings in the case. The defense argues that Carmelo's constitutional rights were violated during the trial. Among their claims, they say that members of the public were improperly excluded from parts of the proceedings, that prosecutors backed away from an alleged off-the-record agreement that influenced Carmelo's decision not to testify, and that the jury received improper instructions before deliberating. Now, they're also taking issue with comments that Judge Roach made in interviews after the verdict. So according to the defense, the judge went beyond simply discussing the case by saying that Carmelo seems like a nice young man who committed a crime. So the defense says that that suggests that the judge was basically affirming the verdict that the jury had reached. And they argue that those comments create at least the appearance that Judge Roach has already taken a position on issues that he may now have to rule on during the post-trial process. So as of now, these allegations are raised by the defense in their post-trial motions. The prosecution will have an opportunity to respond, and ultimately it will be up to the court to decide whether any of these claims warrant a new trial or whether Judge Roach should be removed from the case. So that's where we're at with that one. We will continue to follow it and let you know what happens next. All right, let's move on to an update on a case out of Idaho. All right, y'all know that there has been a lot of debate about vaccines and what's safe for children. One case that has gotten a lot of attention involves an Idaho mother named Andrea Shaw. She became a prominent figure in the anti-vaccine movement after the deaths of her 18-month-old twins. Now, Andrea claimed that her twins, Dallas and Tyson, died as a result of routine immunizations in May of 2025. The two children were found dead together at the family's home in Payette, Ohio. Now, according to Andrea, she had expressed concerns to her pediatrician about vaccinating the twins, particularly the flu shot, because she said that her husband's family had a history of vaccine reactions, and it made her nervous to give that to her twins. She said that the doctor reassured her and convinced her to go ahead and move forward with the vaccines anyway. Now, Andrea claimed that about 2 days later, the twins became very lethargic and they developed diarrhea, so she took them to the hospital. But the staff told her, no big deal, those are typical post-vaccination symptoms, and they sent the family home. Now, Andrea said that 2 days after that, she found both children face down in their cribs. In interviews afterward, Andrea said that she wished she had been anti-vaccine. Now, following the twins' death, Andrea became closely associated with several prominent anti-vaccine activists, and a fundraiser raised more than $12,000 for the family. But y'all, this case took a dramatic turn on June 30th of this year because Andrea was actually arrested in connection with her children's deaths. A grand jury indicted her on 2 counts of first-degree murder. They said that she willfully and with premeditation suffocated both of those babies. She is currently being held on a $2 million bond. So now, in a newly filed motion, Andrea's attorneys are asking the court to reduce that bond so that she can care for her newborn baby while she is awaiting trial for the deaths of her other 2 babies. Now, in the filing, her attorneys describe Andrea as sweet and quiet. They say that she keeps to herself and she is not a threat to anyone. So right now, she remains in jail. We will see what happens. We'll be right back. All right, I want to talk now about one case that has absolutely shocked the country. Y'all, this one comes out of Venton County, Ohio, and it actually started with something that on the surface kind of seemed fairly routine. On June 30th, deputies went to a home to serve an arrest warrant for a man named Gary Siders Jr. Now, he had been charged with 4 counts of public indecency after allegedly exposing himself on 4 separate occasions during the last week of May. But when officers arrived to the house, they found something that they never expected. I don't think anybody would ever expect this. Inside this small home were 16 children, ranging in ages from just 18 months old to 18 years old. Now, authorities say that they were living in what they described as deplorable conditions. And y'all, we're not talking about like a cluttered house. Investigators say that these children were living in conditions that were dangerous to their health. According to investigators, 20 people, including 16 children and 4 adults, were living in a house that's only about 1,300 square feet. There's 5 rooms, 1 bathroom, and a small basement. That is 20 people sharing 1 bathroom, y'all. Now, authorities say that most of the children spent the majority of their time confined to a single 12 by 12 foot room that was just like contaminated with human waste, trash, and filth, just bad conditions. Now, many of the kids apparently appeared malnourished, and 7 of the children were taken to the hospital. 2 of them had to be airlifted, and 1 was listed in critical condition. During a press conference, Ohio's Attorney General even said that investigators believed that if authorities had waited another 24 hours, they would have been dealing with the death of one or more of those children. Now, with 16 children involved, a lot of people kind of immediately wondered if this was some sort of trafficking situation. But investigators say that that's not the case. Prosecutors have actually described this as an intra-family abuse and neglect case. The children have now been removed from the home and placed in the temporary custody of the state. Now, 4 adults living in the house were the children's parents and grandparents. So we have Elizabeth Siders, Gary Siders Jr., they're married. And then you have Gary Jr.'s parents, Christina Siders and Gary Siders Sr. Now, all 4 have been charged with 16 counts of endangering children, and prosecutors allege that the abuse resulted in serious physical harm. But all 4 have pleaded not guilty. Now, one of the biggest questions that I think everyone is asking here is, how does something like this happen without anyone noticing? Because y'all remember, the oldest was 18 years old. But according to investigators, none of the children had ever really been enrolled in school. They had very little contact with the outside world, and they largely avoided any of the systems that would normally identify children in need. So investigators said that they kind of went under the radar. They also said that many of the children had significant developmental delays. Now, according to one news report, many of the kids were nonverbal, and the oldest child, who is now 18 years old, could not even spell her own name. But here's where the timeline gets a little more interesting, because I did a little digging into the family's background, and public records show that Gary Jr. and Elizabeth lived like 2 houses apart when they decided to get married. They were married in 2008. But okay, here's the thing. At the time, Gary Jr. was 18 years old and he had completed 9th grade. Elizabeth was 7 months pregnant, had only completed 8th grade, and she was 15 years old. Because she was a minor, all 4 parents and the judge signed off on that marriage. And then 2 months later, their child was born. So 18-year-old Gary Jr. married a 15-year-old who was 7 months pregnant. Now, I don't want to speculate about what all of that means, but learning that Elizabeth herself was only 15 years old when she became a wife and mother certainly adds another layer to this story. And Ronnie Fletcher, who is the uncle to the children, said that Elizabeth had a really tough life at home before she married into the Siders family. And when she got married at 15, it was basically like an escape from her terrible home life. Now, there are also social media posts from someone who said that he is Elizabeth's brother, and he said that Elizabeth had been indoctrinated. He said that he and Elizabeth were estranged for like 15 years, but had recently reconnected. And also, her attorney has said that when he met with her in jail, she appeared timid and exhausted and distraught, but that the first thing that she asked about was whether the children were okay and if she could see them. Apparently, she said that her and Gary Jr. had always planned on having a big family. Now, as far as criminal histories, I don't really think there was anything I could find. I mean, there is, of course, the pending indecent exposure charges for Gary Jr., but other than that, I didn't find a whole lot. There was a ticket almost 10 years ago for Gary Jr. for not having a booster seat for one of the kids. And Gary Sr. and Christina both had some small civil claims stuff that were from like more than 20 years ago. And Gary Sr. also had a couple of DUIs from decades ago as well. But we do know that there has been an ongoing investigation into the Siders' home involving the Ohio Bureau of Investigation. But there are no details yet on that have come out, so, or at least not at the time of this recording. Now, we learned the ages of the 16 children. They were 18, 16, 15, 14, 13, 11, 10, 8, 6, 5, and then there were 4-year-old twins, 2-year-old twins, and 18-month-old twins. Now, records show that the couple had another set of twin girls in 2022. Now, those babies were born really early. She was only 24 weeks along, and they were conjoined at the chest and sadly died right after being born. There's a memorial marker kind of outside of the home in the grass for those two babies. So this case is obviously still in the very early stages, but we do know a little bit more about what's happening now. Gary Sr., who is 73, has reportedly experienced like significant health issues, and questions have also been raised about his competency to even stand trial. News broke on Wednesday that he had apparently suffered some kind of fall while in jail, so he was taken to a local hospital. Well, that hospital recommended that he be sent to a larger hospital because apparently the medical care that he needs would bankrupt Venton County. If he ends up being released from the hospital, then he will return home, but will have a GPS monitor. Now, his attorney has requested a competency hearing, and they are considering a not guilty by reason of insanity defense. And apparently his attorney said that he was having trouble like even understanding the case, the legal process, and was even unable to give basic facts about himself to his attorney. So I don't know. We'll keep an eye on this one as more information comes out, because I have a feeling we're only beginning to understand what happened inside that home. All right, we're going from a brand new case to one that we have been following for years. Now, this case had a big development this week, and that is the case of Barry Morphew. Now, if you need a quick refresher, Barry Morphew is accused of murdering his wife, Suzanne, who disappeared on Mother's Day weekend in May of 2020 after reportedly going out for a bike ride near their home in Colorado. Now, for years, Barry maintained that Suzanne simply vanished, and he was originally charged with her murder in 2021, but that case was dismissed before trial. Then in 2023, Suzanne's remains were discovered in a remote area of Colorado, and Barry was indicted and arrested again. Now, he has pleaded not guilty and continues to maintain his innocence. But this week, Barry was back in court, and the judge officially set his new trial date for July 19th of 2027. Now, the trial had originally been scheduled to begin this October, but the defense asked for more time, arguing that they are still kind of working through what they described as a mountain of discovery. Now, prosecutors opposed the delay, and Suzanne's family also objected, saying that they have already waited years for answers and they desperately want closure. But the judge ultimately granted the continuance, saying the priority is making sure both sides have enough time to prepare so that this case only has to be tried once. Now, the parties are expected back in court in September for the next motions hearing. And prosecutors also revealed this week that they intend to introduce evidence that they say shows a history of physical abuse in the Morphew's marriage, although the defense disputes that domestic violence is an issue in this case. So I'll let you know what happens on that one. All right, we also have a new trial that got underway this week. This one's out of New Mexico, and the allegations in this one are incredibly disturbing. 30-year-old Isaac Apodaca is on trial for the 2022 murder of 21-year-old Grace Jennings. Prosecutors say that Isaac conspired with his girlfriend, Kiera McCulley, to kill Grace with a sword. So apparently about 10 years ago, Isaac and Grace were together. That means that Isaac was 20 at the time and Grace was only 16. Now, he acknowledges that that was illegal, but Kiera, Isaac's current girlfriend, also said that she had been in a relationship with Grace prior to either of them dating Isaac. Okay, so then fast forward all these years and Isaac and Kiera are dating. Well, Isaac invites Grace to come stay with them at their house. And Isaac said that the three of them shared a bed, but denied there being any kind of sexual relationship that involved Grace. So according to investigators, Isaac's own mother called 911 after her son told her that he had witnessed his girlfriend, Kiera, kill another woman with a sword. So when deputies arrived, they found Grace Jennings dead in a detached garage with multiple chop wounds. Y'all, it was so bad that officers said it appeared that her left ear had been chopped off. And there was a blood-covered sword recovered from the scene. And Kiera had fresh cuts on her hands that she had covered with bandages. So investigators looked around the house and they found a washing machine running, and there was only like 15 minutes left on the cycle. So prosecutors said that that was part of an attempt to destroy evidence. Now, Kiara has already pleaded guilty, and she accepted a 30-year sentence in exchange for testifying truthfully against Isaac. And originally, Kiara told officers that she did not know what happened, but she admitted that she was mad that Isaac had invited Grace to stay with them, and she said that she had had some dreams about harming Grace. But prosecutors say that text messages will show that Isaac pressured and encouraged Kiara to carry out the killing, basically aggressively coercing her into it. Now, if convicted of first-degree murder and conspiracy, Isaac can face life in prison. So that one started this week, and it is a trial that we are definitely keeping an eye on. All right, now it wouldn't be an episode of Court Report if there wasn't a Karen Reed update, right? If you listened to last week's Court Report, you know that there was some drama in the Karen Reed civil case. Are we surprised? Of course not. As a quick recap, Judge Mark Gildy ordered an emergency hearing and required all attorneys and parties to appear in court with just 48 hours notice during a holiday week. But when everyone arrived, the judge did not allow any of the sides to speak. Now, the issue centered on confidential medical information involving former Massachusetts State Police Trooper Michael Proctor. The judge believed that information that had been filed under seal may have been improperly disclosed, as in nobody's supposed to see this, but somebody saw it because it was posted on X. Now, after that hearing, Karen Reed's attorneys filed a series of emergency motions arguing the judge's conclusion was based on an incorrect timeline. Okay, so last week I went over this, and I said last week it was just a theory, it was pure speculation, it was just based on kind of internet research, right? But apparently it was right, because the defense claimed that the information that the court believed had been leaked was actually publicly available already before the sealed filing was ever submitted. Now, according to the defense, that key piece of evidence was the screenshot of the X post that had appeared to be posted after the sealed filing by like 30 minutes. But they said basically the same thing we said last week, that that timestamp was displayed in a different time zone. So once it was converted to Eastern time, they argue that the post was actually published more than 3 hours before the sealed filing, meaning it could not have come from confidential court documents. And also, Turtle Boy, the one who posted it, had already said that he had a source who told him that, and he said that on a live stream like a couple days earlier. The defense also argued that they were never given the chance to correct the record during the emergency hearing because the judge ended the proceeding without allowing counsel to respond. And Judge Gildy has now responded, but not in the way the defense was hoping, probably, because rather than deciding whether the timeline was correct or acknowledging any of that, he basically ruled that these motions to clarify the record were the wrong legal vehicle, basically, to raise those arguments. In other words, he didn't decide whether the defense was right or wrong about the alleged leak. He just said they needed to use a different type of motion if they wanted the court to reconsider the issue. So for now, the dispute over whether there was actually any improper disclosure remains unresolved. And given this case's history, it's probably safe to assume that we have not heard the last of it. Well, that'll do it for this week's court report. And as always, I will keep following the cases and bring you the biggest developments as they happen. And also, don't forget, Saturday morning, I will be releasing a full breakdown of the Tyler Robinson preliminary hearing. Now, this wasn't just another hearing. This was days of testimony, hours of legal arguments, and some of the most significant evidence that we have seen in this case so far. We have new information, never before seen, never before heard. So we will walk through what the witnesses said, what investigators revealed, and the key evidence that both sides fought over, and what all of it could mean as this death penalty case moves forward. Now, if you've been trying to keep up with the headlines, but you feel like you're missing the bigger picture, that is exactly what this episode is for. So I will see you back here Saturday morning for the full Tyler Robinson breakdown. And that's your court report for the week. The stories continue, the evidence keeps coming, and the legal process is far from over. I'll be back next week with the latest developments. Until then, keep asking questions, keep looking at the evidence, and decide for yourself what you believe. My name is Brandy Churchwell, creator and host of the 13th Juror podcast. If you enjoyed this episode, be sure to follow the show on your favorite podcast platform and leave a rating or review. It helps more listeners discover the... All right. What do you think? That is court report. So we were talking about court report and kind of, I've still got bedhead. I just remembered I have not brushed my hair. That's okay. I only got like 4 hours of sleep. So it's okay. I stayed up finishing court report last night. So we were talking a little bit about court report and I was trying to explain kind of what it was. And it's basically just like a quick rundown of all the court happenings for the week and all that. There's so much that I could fit in there. Actually, okay, so who, if anyone, follows me on Facebook? I posted something this morning because I've been up early. I feel like I'm up always early. But I've been up early working all morning. And hold on, let me find. That's not what I needed. That's not what I needed. That's not what I needed. Where's what I needed? I'm just going to have to open another one. Hold on. Hold, please. Please hold. All right. If you follow me on Facebook, you probably saw that I posted this morning. This is what I was working on all morning. This is like a crazy story right out of my neck of the woods. How do I pull this up without accidentally showing all of my personal information? Try to do it this way. So y'all know I live in Panama City Beach, but I'm from Georgia. So this involves a little bit of both, which is kind of wild. All right, let me see. Okay. There we go. All right, so this is what I put on there. This is what I was working on all morning, going through police reports and arrest records and stuff. Okay, so I'll kind of read you what I wrote. So this, I put, okay, y'all, I have a really disturbing story coming out of my neck of the woods this morning, not far from me here in Panama City Beach. If you're an 850 local, 850 is our area code. That's what we call each other. We the 850 locals. It's fine. If you're an 850 local, you probably remember seeing the missing person alerts for 43-year-old Jason Colthart from Niceville. Jason, who is also known as Jersey, was a father who disappeared at the end of May after he was last seen leaving the college condominiums on East College Boulevard. So for weeks, his family searched for answers. Then on June 25th, investigators received information that Jason's body had allegedly been buried on a property on Sunset Lane in Freeport. Freeport is not too far from here. Now, because the property is in Walton County, Niceville police contacted the Walton County Sheriff's Office, who obtained a search warrant the same day. And when investigators searched the property, they found a shallow grave. Jason's remains have now been positively identified. So obviously it's an absolutely heartbreaking outcome for his family. But now we are learning what investigators believe happened, or at least I am, because I'm nosy and started pulling records. And it's kind of shocking. Okay, so I spent the whole morning digging through police reports, and here's what I pieced together. According to investigators, on June 25th, there were 2 independent witnesses who came forward about what happened, and both pointed to 38-year-old Isabel Johnson as responsible for the murder. That's Isabel Johnson. Let me remove this banner. Isabel lived on the property on Sunset Lane in Freeport, where the body was found, with 2 roommates, Bobby, like female Bobby with an I, Bobby Wagstaff, and James Teal. I just realized that I have an E on this, and that's not. Here, let me edit this. Because that's not how you spell her name. Next, save. Okay, sorry. So she lived on the property on Sunset Lane in Freeport with her roommates, Bobby Wagstaff and James Teal. Teal suffers from terminal cancer and told investigators that he had been afraid to come forward because he feared retaliation. But he said he decided to tell police everything because, in his words, he was going to die soon anyway. So according to Teal, Isabel had previously told him about killing a man that they called Jersey, which investigators say is Jason Coulthard. Now, Teal said that Isabel and Bobby, the other roommate, had dug the grave on their property, like right beside a shed. He told investigators or detectives that he never actually saw Jason's body, but he knew that the hole that was dug was intended for him. And after that hole was filled in, Isabel parked a car over it to conceal it. It was like a black Cadillac, and then she left town and went to Georgia. Okay, the other witness that came forward was Isabel's boyfriend, Matthew Sweeney, and he told detectives that he and Isabel were in Georgia on June 2nd when Isabel received a phone call from Bobby, her roommate, that had helped her dig the grave. So Sweeney said that Bobby told Isabel that a dog had dug up Jason's body and she needed to return to Florida to help clean all of that up. So Sweeney said that Isabel had another friend drive her back to Freeport, and then about a day and a half later, she returned to Georgia. When she got back, she confessed to Sweeney, her boyfriend, to killing Jason and burying him on the property. She told him that she used a zip tie around his neck, buried him in the yard, and then parked a black Cadillac over the grave to hide it. After the dog dug up the burial site, she told him that when she went back, she said that she poured concrete over the area so that the dog could not dig it up again. She claimed that she killed Jason because he was abusive and was coercing her into criminal activity, and he wanted more from their relationship. That's what she said. So investigators got these 2 tips, and then they got a search warrant, went to search the property, and then they found Jason's body buried beneath this freshly poured concrete. And the report said that there was still live grass underneath the concrete. So it was obviously, it had been poured recently. Investigators also recovered a white zip tie around Jason's neck, and there were similar zip ties found inside the residence. And Jason's credit cards were also recovered from the property, along with methamphetamine inside the home. Okay, but that's only part of the story. So next picture. These people. The middle is Bobby, and then the 2 on the outside, I'm about to tell you about them. Okay, so according to the other police reports, I'm telling you, I've been like all on these all morning. After Jason's body was discovered, investigators believe that multiple people had helped Isabel Johnson avoid arrest. They say that 63-year-old Martin and Sandra Leverton, those are the 2 on the outside of this picture, first became involved after Isabel contacted them while she was in Georgia and asked them to bail her out of jail. This was like in early June. The couple drove to Georgia, picked her up, and brought her and a white van back to Florida. A few weeks later, after investigators searched the Sunset Lane property and discovered Jason's remains, Martin and Sandra allegedly learned that police were looking for Isabel. They actually even came to their house looking for her. Isabel had admitted to them, according to the reports, Isabel had admitted to them that she had killed Jason. And despite that, police said that the couple continued helping her evade law enforcement. So they helped to hide Isabel. They gave her an old phone so that she could stay in contact. They tried to arrange transportation for her to get out of Florida. They connected her with other people who might help her and even suggested places where she could hide from police. And the arrest report said that they deleted, or says that deleted text messages were recovered from her phone and Sandra's phone, and between her and Isabel, and they were discussing screenshots that Isabel had sent of text messages between her and Jason. And at one point, Sandra here is allegedly, you know, according to the police report, is like referenced using a zip tie to kill Jason, like before it happened. And Sandra later was like, oh yeah, I was just joking. JK, LOL. So last week, Martin and Sandra were both arrested and charged with knowingly helping Isabel Johnson evade law enforcement. So the sheriff warned, like, anyone helping her, y'all are going to jail too. So as for Isabel, this is Isabel. She remains wanted. And this is where I said on my post, I was like, this is where I need y'all's help. I live in the Panhandle of Florida, and I was born and raised in Georgia. There's another spelling mistake. So I know I have a ton of family and friends and followers in those areas. So be on the lookout. Investigators say that Isabel has used numerous aliases, including Harley, Jessica Elaine Bowman, Jessica Elaine Thrush, Jessica Dowdy, and others. She's 5'3", brown hair, hazel eyes, and the Walton County Sheriff's Office has also made it very clear that anyone who knowingly helps her avoid arrest could face criminal charges themselves. So if you know anything, contact Walton County Sheriff's Office or Emerald Coast Crime Stoppers, who is also potentially offering a cash reward. So crazy stuff, really sad. I hate it for that family because, I mean, it's terrible. Like, just to... And she's like, yeah, I just killed him with a zip tie and put him on the property and parked a car over him. Like, how messed up is that? People are nuts. All right, let me get our hearing pulled up. We haven't started yet, but I got us ready. Oh no, what? Stop pressing buttons, Brandy. Oh my gosh, we were, me and Chat Daddy were watching TV last night when we finished. I was like, I just want to watch something stupid and mindless after I finished with everything. And then of course I pressed buttons and messed it all up. And he was like, stop pressing buttons, Brandy. Oh, thank you so much for the super chat. Thank you. Thank you. I appreciate that. You're the best. Thank you. Thank you. Thank you. Thank you. She didn't finish reading her book, How to Get Away with Murder. That's right. True that, yo. All right, let me close out some of this stuff. I've got stuff everywhere. What you panting so loud for, Tens? They just got back. The dogs just got back. Did you have so much fun? Did you have so much fun on the golf cart? People who don't know that I have my dogs here and are just tuning in are like, she's crazy. She's talking to herself. Baby voices. All right, I've got us ready. Am I frozen? I'm frozen? Everything's frozen. There it goes. Oh, dang. Morning, everyone. I'll be in and out today. Our house AC went out last night. It was 112 here yesterday. Yikes. 108 today. Goodness gracious. Yeah, Isabel's on the run. So if you see that heifer, call it in. Good morning. Good morning. Hello, hello. Baron Coleman gave you a shout out on his live the other night. Showed a spreadsheet you made. It was cool. Oh yeah, the timeline. Yeah, somebody sent me a screenshot of that, and then there was somebody else too. Hold on, let me look at my screenshot. Somebody else sent me a screenshot of. Oh, Dave Neal. Dave Neal did too. So that's cool. I put them out there into the universe for whoever to use them. Everybody's welcome to use them. I love it. Y'all know I love a timeline. Y'all know I love a timeline. Hello, hello. You haven't missed anything yet. Well, we listened to this week's court report, but you can catch that on YouTube. You don't have to rewind that for this. And then I told you about some crazy stuff that happened in my neck of the woods and a 38-year-old fugitive on the run now. The new weekly court report episodes are fantastic. Much appreciated. Thank you. I've enjoyed doing them too. It kind of helps me like really keep up with everything that's going on, because if I'm only focusing on the episodes that I'm like the main episodes I'm doing each week, then I've been losing touch with some of the cases that I like keeping up with. So I was like, okay, well, I'm doing all these spreadsheets anyway to kind of keep up with updates. Why not just share it with y'all? That way we can all share it together. Hello, Diana from Dallas. You have not missed much of anything yet. Just us yapping. Yapping. This is good. It's like sparkling water. Black cherry. They are on YouTube. The court report episodes are on YouTube and on the podcast feed. So anywhere you get your podcast, and also on YouTube. But it's just audio. I think I might start doing the court report episodes video starting next week. But right now they're just audio. I listened to your new court report earlier. It's fantastic. Thank you. It seems I only missed the local fugitive drama. That's on my Facebook too, but I just kind of went over it and showed who it was because that's crazy. We're just waiting on them to show up. Do you hear, babe, do you hear how loud Tinsley's panting? But she won't like go in there and like get more water or anything. She wants to lay like right here. Tinsley, go get you some water, baby. Go get you some water. She's got her duck. See her walking around with her little duck. And she's panting just as loud, but she's so cute. My little babies. All right. So how long do we think that today is going to take? Do we think that we're going to get done? We better get done before lunch. We just have the one ATF agent. And if it's anything like yesterday, gosh, I hope it's nothing like yesterday. Because that one was like, do we have an over-under on whether this truly will be a HOF day? It has to be a HOF day because I have to record the episode on this tonight, and all I got done on it was the intro, and I need to write out the rest of it so that I can record it tonight so that it can be released tomorrow. And I have dinner plans tonight. Me and Chat Daddy are going out with my bestie and her husband to dinner, and I really want to do that because I've been stuck in this office all week. I hope today is not as painful as yesterday. Same. I missed yesterday. Stupid work ruining everything. Quick recap. Okay, so here's what I'm going to say about yesterday. Yesterday, some of the most important information came out during the first part of the day. During the last part of the day, I wanted to pull my hair out. So I would recommend going back and watching, okay, the very first part of the day, the first, 2 hours are just them arguing over what's going to be shown. You can skip that if you're not into like the legal argument, if you're just wanting to see the evidence stuff. When we came back from that first break, that's when all the big stuff happens. That's the part I would recommend rewatching. And then the last part of the day, I struggled. I was literally texting our mod group chat, like, y'all, I cannot focus. I am losing focus. I am trying so hard. I could not do it. It was so bad. So bad. Especially at the end of the day when it's technical stuff, and then you've had such a big explosive day, and then all of a sudden it's like Tom snooze, and it's fine. Everything's fine. But yes, so there are some really important parts from yesterday. The first couple hours is just them arguing. The last couple hours is brutal. But all that stuff in between was big. It was 84 years. We were literally live for like 9 hours yesterday, and it felt like 18 because of that last part of the day. The bullet part, do you think that helps? No, I mean, no, if I'm being honest, because think about this. This is like a jury of not experts, not people who are wanting, one outcome or the other. This is a jury of, his peers. And this is going to be a situation, in my opinion, this is just my opinion. It's my opinion. This is going to be a situation where the jury hears that they're going to see those confessions. They are going to, and I don't know if y'all saw this. I noticed it yesterday, but I didn't point it out. I made a face on the live stream because y'all know I can't fix my face. I made a face on the live stream, but I did not point it out. But I don't know if y'all noticed. They accidentally showed that letter on the screen yesterday. And I made a face. And I made a note on the timestamp, and I went back and looked at it, but I did not point it out because I was like, I'm not going to break a court order. It's part of the media, but somebody else did, so I didn't have to. So everybody's posting it all online, and it's out there. That letter, the only part that we saw in the documents before was him saying, I had the chance to take Charlie Kirk out, and I took it. And hold on, let me see. Yeah, I got I was going to say, I'm pretty sure I wrote down the timestamp on my own thing. Yep. Okay. Anyway. But I didn't say anything because I was like, okay, I'm going to try to be a responsible journalist, and I'm not going to point out the stuff that we are not supposed to be looking at. But y'all know I'm nosy, so I went back and looked anyway. But I didn't point it out publicly, which is what I'm supposed to do. So, but then everybody else did. So I didn't have to do it. They did my dirty work. Not my dirty work. They did their own dirty work. I just benefited from it. And I went back and looked. It's spicy, y'all. It is more than just that. I can show you now because now it ain't my fault. I'm not the one that did it. I can pull up somebody else's post. Let's see. I have Shania Twain in my head. Is that weird? Okay. It says, here, I'll show you. If you're reading this, I can't get that word. If you're reading this, something, my text, put my text up, my text, something, then I am so sorry. I left the house this morning on a mission and set an auto text. I can't talk. I am likely dead or facing a lengthy prison sentence. I had the opportunity to take out Charlie Kirk and I took it. I don't know if I will or / have succeeded, but I had hoped to make it home to you. I wish we could have lived in, and then that's it. Oh, if you are reading this per my text. Look at you. Look at you. I couldn't. I was like, pet my text? At my text? Per. Look at y'all making so much sense. So, and it says it's addressed to Luna. Remember that one part of the interview yesterday where he said, where Twig says that he goes by Luna sometimes to some people, but it's not like an overall thing?
Court is now in session. Calling case 251-403-576, State of Utah versus Tyler James Robinson.
What is happening?
Counsel, please enter your appearances.
Wait, hold on. The dubbing is off.
Chad Grunander, Ryan McBride, Lauren.
Hold on, please. Hold, please. I have to fix the dubbing or else it's going to drive me absolutely nuts.
Hunt, David Sturgill for the state, and the county attorney Jeff Gray and Chris Ballard are also here.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, and Michael Berg here for Mr. Robinson, who's seated in the courtroom.
Good morning.
Good morning.
Mr. Robinson, good morning to you. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Ms. Kirk, good morning to you as well. First, with respect to courtroom protocol, to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern.
Final day. Final day.
The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings.
Lifetime.
Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos. My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley, Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes. Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that
I invite you to join me to shut your phone up.
Proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
Oh boy.
Mr. Novak.
Oh boy.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders.
Here we go.
And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it. And they state to the court that they do not have a problem with it.
Is this about the note?
We also spent many, many, many hours of court
Just
time
about the note.
addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was.
This is why I didn't want to show it.
Without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office.
What?
Obviously, I'm not going to do that. But my point is it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding,
It's too late, my guy.
proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is.
We are.
This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera was captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage. And I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and take.
I mean, it's even on New York Post.
And I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long forward
Maybe he's
past days,
watching us.
That's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. For the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand it. There's two exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those two exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit. And recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant in this case.
It is.
That was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen. But since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
the court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
There goes our Hoff day. Hold on. I'm about to pull up the search warrant that he's talking about because that picture shows the handwritten part, which we have not seen the handwriting before. And I get that he said that that's not allowed. But that full text is available. Hold on. Let me pull it up. Let me find my documentos. Here we go. Okay. Let me find. The boyfriend was identified as Lance Twiggs. During the interview, Lance showed investigators text messages. Hold on, I gotta scroll through. I should have highlighted it. So ETA. Here's the Discord messages. See, the Discord messages are bad too. Lance Twiggs' cell phone. Okay, a photograph of the letter that Tyler Robinson wrote to him. For context, Tyler Robinson had sent a message to Lance Twiggs that said, drop what you were doing and look under my keyboard. All right, here's the full thing. So it says, here, let me zoom in so you can see it. Here it is. Luna, if you are reading this per my text, then I am so sorry. I left the house this morning on a mission and set an auto text. I don't know why I struggle with that sentence so much. I am likely dead or facing a lengthy prison sentence. I had the opportunity to take out Charlie Kirk and I took it. I don't know if I will / have succeeded, but I had hoped to make it home to you. I wish we could have lived in a world where this did not feel necessary. I wish I could have stayed for you and lived our lives together. I lack the words to express how much I love you and how very much you mean to me. Please try and find joy in this life. I love you always, Tyler. So this is public record, which is what the media guy was saying. The camera guy was not like, oh, let me zoom in on that, even though I'm not, or camera lady was not like, let me zoom in on that, even though I'm not supposed to. It was shown before they moved the camera, but I get why it's an issue. I just don't think it's quite as dramatic as he was making it out to be. Is the issue that the exhibit was displayed before it should have been and the camera caught it? Yeah, like they had the burnt part that was allowed to be shown. And then they put this one on the screen to show it next to that, to kind of show like, hey, this is the letter that they tried to burn, or that they did burn, or whatever, to compare them, to show like this is what it was. And so it just caught it in the very corner of the monitor. And so the defense liked that the conspiracy theorists weren't happy with the version that was in the arrest warrant. The showing of the actual letter with his handwriting is what they did not want. Whoopsie. I think, you know, I understand where they're coming from, and I get it. But it is public record. It is a heck of a I did it letter. There's also the hold on, let me find the Discord messages. That was the in one of the messages that Lance showed to investigators, Tyler posted the following message in a group chat. Quote, "Hey guys, I have bad news for you all. It was me at UVU yesterday. I'm sorry for all of this. I'm surrendering through a sheriff friend in a few moments. Thanks for all the good times and laughs. You've all been so amazing. Thank you all for everything." And then the rest of the text are on here. Well, that's a nice close-up of that hair. I've been using conditioner. A burned letter compared to what? So they had a burned letter that they found in the apartment, and then they had a picture of the letter that was taken on Twiggs's phone. That is very close up hair. Oh my gosh, could you imagine if it was like a close up on like your nose or something? Like that would be awful. But the hair looks great. It's great. It's good. Everything's fine. Luscious locks. They said they had his phone on the 11th. Had Twiggs's phone? Or Tyler's phone? Because Tyler turned himself in at, I think he got there. I think they called and said that he was going to turn himself in around 8-ish. If I remember right, I have to go back and look at my notes. And then I think he got there around 9 is what Agent Davis said. And that last message that was sent from Discord was sent, I have to look at my notes. I think it was sent around 8 o'clock or 7:42 or something like that. So he said he was going to go turn himself in. And that was the last text or Discord message that was sent. Yeah, the court order was for the handwritten letter to not be shown. And they didn't do it on purpose. You can tell like it wasn't like a, F the police, we're doing what we want type thing. This was just, never burned a letter. So yeah, I've never burned a letter. On purpose does matter when you're talking about potential sanctions. Because the sanctions would be much harsher if they did it on purpose. This isn't the trial. They'll still be able to find a jury whether or not that letter was shown. Yeah, it's like they were saying yesterday, like it's like that judge's ruling yesterday was there are going to be remedies when when it gets to trial, there are going to be remedies. That's part of the voir dire process when they're asking jurors about, what coverage they've seen of this. Let's see. The lawyer should give a heads up to avoid this. Yeah, I mean, we've seen this happen before, like when they've had like graphic pictures and stuff like that were shown that, shouldn't have been. And then the camera person moved away real quick and stuff like that. It's going to happen. Not in a constitutional violation. I mean, agree to disagree. From every time that I've ever seen judges come up with sanctions for stuff like this, they have always taken into account, first off, whether or not the order was actually violated, and then whether it was an intentional violation or an accidental violation, and then how serious the violation was, and whether or not it caused prejudice. And, there's a lot of factors that go into that. So we'll have to agree to disagree on that. I think that the intent is absolutely something that they consider based on what I've seen. I've written a lot of things just to get it out of my system, then burned it. It can be quite therapeutic if you want to put something behind you. That makes sense. It opens the door for the trial to be thrown out or a new trial. But this isn't a trial. It's a preliminary hearing. I think that's a huge part of this. This isn't a trial. So this is, once again, I mean, the presence of any potential remedies for the violation are going to be a huge factor in the sanctions for it. So a trial gets thrown out if there is no other remedy. This isn't a trial, it's a preliminary hearing. And the letter being shown briefly, unintentionally, yes, it is now out there in the world. And the handwriting part of it was not out there in the world. The words were, the handwriting part was not. So yes, you can't unring that bell, but it's not, this can't be thrown out because this is a preliminary hearing. It's not a trial. And one of the remedies that is potential, remedy for this would be handled during voir dire of the jury process. Remember when Brian Laundrie's mother said burn after reading, but he didn't? That didn't turn out well for him. Good morning. Good morning. What you have missed so far is they have brought up the issue of having the camera person catch the screen when the handwritten note was placed yesterday, and the defense is wanting sanctions, and now they've argued that, and now they're on a break. Triangle of ceiling lights are our new courtroom only fan. It could lead, I think it could lead to the media being barred from live streaming it. That way it can't happen again. It could. I mean, if this were like a huge, thing, like, okay, like look at the Aaron Spencer case. That was only in the preliminary stages, but of course that got thrown out, so there was no case. Because there was no remedy for that violation. Like the not having the footage and all of that, there was no remedy for that, so they threw out that case. And actually they said, was it yesterday or the day before, it's all run together, that they weren't going to pursue that again, so it's over. So that's like an example of like an extreme case where there is no remedy other than throwing out the case. I bet they're screaming at each other right now. They're in a whole big fight. Maybe they're like, how they have, I I picture them back there, like with the, what's the American Gladiators, like where they have like the things. Lindsay says this won't throw the whole case. That's kind of absurd. However, I am curious if the defense doesn't want that out there because of the handwriting aspect, being that the bullet's written. That could be it. Yeah, I agree. I don't think that this is something that would throw out the whole case, but there will be some kind of sanctions or whatever because there was an issue, but Brady, the judge decides if there's enough evidence to go forward. Yes, then at any point can he say, I've heard enough to move forward with a trial. Yeah, so today's the last day of the preliminary hearing. So they're going to finish all of their arguments today. And then each side so the prosecution will submit their briefs, and it's due like 14 days after they get the transcripts. And then they have like 35 pages where they can kind of plead their case on, how they've met their standard and why it should go to trial. And then the defense will give their response. That's due 14 days after that. And then the prosecution will file their final reply, which is half that page. It's like 18 pages. And then that'll be due 7 days after the defense. And then they'll do the oral arguments on it on September 1st. And then the judge will make his decision. So is it conclusive that the Dremel was used on the casings? It isn't really the best tool for metal etching. Well, they said that, so Twig said that he had asked him for the Dremel tool so that he could do it. Like, so that came directly from his interview where he said, he asked me for this because he wanted to do it. And then we saw the pictures where he had etched, or where the casings were etched, and then his DNA was on the Dremel and on the bits and on the cord and all that. And he even talked about it in his text message too, because he made a joke about how one of them, which we didn't know what it meant, but we Googled it yesterday. We learned all about that. But one of them was like some kind of meme joke about furries or something. So he talked about it in his text. So all of that kind of came together to bring all that together. Thank goodness they threw out Aaron Spencer, right? How does the media get sanctioned? Fined? I'm trying to think if I've ever even seen the media get sanctioned. I mean, I've seen attorneys get sanctioned. I can't think of any media that I've ever actually seen get sanctioned. Fines are, potentially a part of being sanctioned, but stricter compliance with rules, I guess they could hold them in contempt. I've never seen media get sanctioned. We've seen it happen all the time with them, like unintentionally getting something they weren't supposed to get, but then it's always just kind of like a scolding. And then, sometimes they've changed the rules. What was it? The Melly trial, where the defense attorney got mad because I'm trying to remember. It's been a few years. The defense attorney got mad because the camera kept showing them at the table. And so they ended up changing the rules, and the cameraman was no longer allowed to point the camera toward them or something. I can't remember the exact details, but there was something like that on that one. So changed the rules. But when they said something about it, the cameraman before that was zooming in every time there wasn't supposed to be something on the screen that we weren't allowed to see. They would just zoom in on the judge or on the witness. So that way there's no screens anywhere around. But we were allowed to see that one part. It's just the cameraman didn't know that they were changing the exhibit to something we weren't supposed to see after that. But this is also the very last day of this. So and all we have today is that ATF agent. So I don't think there's any more of the stuff that's going on the screen today that we're not supposed to see anyway. Do you think they'll ban cameras for the rest of the day? No, I don't think so. This judge is very concerned about the transparency of this. So I don't think they'll do that. I could be wrong, but I don't think they will. Closest thing I can think of is when JLR filmed or streamed Morphew pretrial without permission. The judge blocked all media from future proceedings and hearings. Contempt of court for media can be a monetary fine. It can be credentials pulled, ejection from the courtroom, or even the lockup in the most extreme cases. Those were wild times over here.
Be seated. Court is back in session, noting the presence of counsel and all parties. And where we left off is the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that
That'd be a terrible idea.
The court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough.
Okay.
If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday.
Bad idea.
The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to here ordered the media to look into that capability. And that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
You can't get rid of all media for this. That'd be crazy.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Dun, 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 dun. I think transparency, especially in a case like this, is huge. And the judge has felt that too. That's why this was his ruling. We'll just wait right here. At least he's taking his time and wanting to do it right. We'll just all wait right here. Could you imagine though being a new judge and then having like this is like your first big high profile case? Like what a stress ball that would be. I get fair trial, but this is a very public crime. That is true. He is making all of his notes before he gives his ruling. What do you think he'll do? Yeah, talk about a sink or swim moment for real. He could pass his install. We were talking about that the other day, about how they look like they could be long lost cousins or something. We'll just all make our notes while he's doing this. He said he's making his notes and everything and making sure that he documents everybody's points on it and all of that. He's in somebody's chat right now. Because he said he was live streaming this. So he's literally in chat. He's like, yeah, I don't know what to do either. Like they're really annoying me. I'm so over everybody. I was ready to be done yesterday. Maybe he's in our chat. Hey. Blink if you're a 13th juror, Judge. He blinked. Do you see that? Now he's reading what y'all wrote.
All right.
As per my last email.
I'm almost done. I appreciate the party's patience.
See, he's laughing. We got him laughing. We said hi and he's laughing.
This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience.
You can do it, T-Graph. We got you. I bet he can say it. Scout's honor. Or wait, is that 3? What does a scout do? How do you do Scout's honor? I'm not a scout. I guess I shouldn't do Scout's honor if I'm not a scout.
All right.
Podcaster's honor.
Court will issue its ruling on the request by defense.
All right, here we go.
The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
Could you imagine if they had done that yesterday and we didn't get to see that video? I'd have been so mad.
Yes, Mr. Granander, and I'll allow all parties, given the
We just
ruling
can't
of
see
the
the
court,
exhibits
briefly.
anymore.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing
if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence.
That's one of the expert
There's
ones.
a State v. Drozbecki case, which is a Utah Court of Appeals case,
They decided
2010.
that.
Magistrates may
expert,
only
right?
disregard or
Hold on, let me look it up.
discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this,
It's an expert hearing. So it's like the where that's what I thought, where the judge can decide if the expert's testimony will be allowed or all of it or part of it.
Probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution.
I think they're trying to get him from to prevent him from getting so in the weeds like yesterday.
And draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Miss Oliver.
So we're about to get real technical with all of the
Ms. Oliver, if you'd like to come forward and be sworn in.
DNA stuff again.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA.
Oh, hold on, I can put this at 1.25 for the.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
We're cut off from. See, the thing is now if. Are they going to mute us this whole time while they go over this stuff? If so, this is going to be really boring. We're back in real time. So it's admitted into evidence. We can read lips a little bit. So, what y'all doing? Hello, everyone. Well, here's what you missed. This is our view. We're no longer allowed to see exhibits, and they've cut the audio because they're talking about an exhibit. So we're just going to sit here. Wrong answers only. What are they talking about? Ham sandwiches. Ham sandwiches. I wonder if Judge Graff is reading the comments too. I would be all up in the chat. People be talking about it and be like, yeah, girl, you should have seen. I mean, I got other things I could be doing. This is crazy. I'm just going to scroll. They're talking about Real Housewives of Salt Lake City. They're talking about the Love Island finale coming up. Remodeling my basement bathroom to silence. That's so fun. So fun. Getting everybody's Chick-fil-A order.
This is the next sample down, 1.2, where the state read paragraph D, admitted paragraph F. You state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors, the council table, and podium.
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur. And that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim, we cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's record.
Right. The order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing, and the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Oh, boy.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that from the FBI testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right. And would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay. Let me pull up Oliver 3 for the witness only. And go to the third page.
I mean, this is all kind of standard stuff that we already know about DNA.
Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yes, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right. And they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30, page 8? Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained, and then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1?
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
Could I refer to my tables in my report?
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
It's kind of crazy. He makes this big deal about
with the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what to simplify, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30.
For the witness only.
Keep going.
It's crazy though because it's like, okay, this is like the part that, this is your chance to call your witness, my dude. Like this is the one who's supposed to help your case. And you're bringing up like the technical stuff on her report, but you're not letting us see it. Seems kind of counterproductive to your own case, but get on it, Tom Smooth. You do you, boo.
There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes. So for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point. So we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would
That's
not
where
be
he's going at.
scientifically defensible, would it?
Correct.
Okay.
That's what he wanted.
Another limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
So the big thing here is he's wanting it to get on the record that where all of these media outlets are like splashing, however he said, splashing across the headline that Tyler Robinson's DNA was found on these things. He's saying, you can't say that, right? Well, no, she can't. Like, she has very specific wording through the DOJ that they are actually allowed to say. And even when the witness who was on the stand gave all of the information about that, she didn't say, oh, his DNA was all up on that mess. What she said was, it is 1 trillion times more likely that, he was a contributor as opposed to him and 2 other unknown individuals. Like, they have all of their words that they have to put in there because that's what they do. It's the same way with experts. It's like, you can't say, you'll have experts that come in there. Even when my husband was in chat yesterday and somebody asked him about trajectory, he's like, well, there's a lot of factors and you can't say that it's always this or always that, but I can give you generalities on whatever. That's a very expert thing to do, and they have their specific wording that they are required to use. They can't say, yep, his DNA was on there. They can say it is 1 trillion times or 1 billion times or however many times more likely that he was a contributor than if it was, like I said, 3 unknown individuals or whatever. So he wants this to be a way to not discredit the DNA, but to diminish the significance of the DNA so that he can make the judge see, oh, it's not like you can't say Tyler's DNA was on there. You have to take in the consideration that there's probabilities and there's whatever. But here's the thing. When you have the DNA and he is 1 quintillion times more likely to be a contributor, and then you have all of the other stuff, that's where this gets so much of its strength from. It's not just like this is the one thing, but we have this, like in a cold case, like where they have their DNA and it's the one thing they have, but then they're like, no, I was out of town. I didn't even live in the state. I wasn't here. I have no idea what you're talking about. Never met that person, whatever. And that's like the only thing they have. This ain't that, bro. Like, this is like, there's a whole bunch of stuff that they presented. So what they're saying is this is all together something. And yes, the media is going to say, yep, his DNA was all over there. But I mean, so you're saying there's a chance that it's not him. So it's 1 trillion times. But then, okay. So let's play that tape to the end. Let's say you're 1 trillion times more likely to have this be his DNA than any other person. What are the odds? How many trillions and quintillions and all that are there that it would be somebody else's DNA, and also him having confessed and him having all of this stuff? Like, what are the chances of it not being his DNA at that point, right? Because think about all of the other stuff, like all of these, this is going to be the prosecution's argument. They're going to do it much more eloquently and legalized than I am, but that's going to be their argument. Like, okay, you don't want us to say the words, like don't say the words that, it's his DNA, but what are the chances it's not based on everything else that has been presented? What are the chances that all of this other evidence points to him, but they were wrong about the DNA? Like, that's just that's what a jury's going to see too.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't want to mischaracterize it. Your testing, none of the testing in any of the 3 reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on a knife?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case graded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive. And so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples,
Like you said, he made contact.
you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I'd say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct.
And again, not because he's a suspect, but because he's associated with that premise.
Correct. And there would have been a likelihood ratio statistic calculated to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go 2 page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs' DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area.
Who, if anyone, thinks this matters?
I want to ask you about
jury.
is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for next generation sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
You know, also the whole thing, there are more texts that did not come out in the preliminary hearing that we will hear during trial that were in the search warrant. For example, he says in one of the text messages that he said a coworker, Lucy's laying in such a weird position, said that a coworker just sent him a screenshot. He's like, a coworker just sent a screenshot of me on campus, like a still shot or whatever. So when the FBI had released those still shots of like, hey, this is our suspect, he's on these text messages saying, hey, that's me. So he's admitting it's him on there. They got his plates when he went back to go try to get his gun, allegedly. This is all allegedly. I'm arguing the prosecution's case here. This is what they're trying to do. They're trying to get to their point of probable cause. According to all of their information, they have the timeline that adds up in the morning with him leaving around 4 a.m., according to Twig's testimony, right? Or his interview. Okay, he left around 4 a.m. Then you have the text where he's admitting, oh, yes, I left really early and I left on a mission. He left the note under the keyboard just in case he didn't come home, and left or set up an automatic text to be sent at 11 o'clock in case he didn't make it home. And that note said, I'll tell you exactly what it said. We'll look at it again. Luna, if you are reading this per my text, then I am so sorry. I left the house this morning on a mission and set an auto text. I am likely dead or facing a lengthy prison sentence. I had the opportunity to take out Charlie Kirk and I took it. I don't know if I will / have succeeded, but I had hoped to make it home to you. I wish I could have stayed for you and lived our lives together. I lack the words to express how much I love you and how very much you mean to me. Please try and find joy in this life. I love you always. Tyler. That's his name, right? Prosecution's going to say that's his name. That's his premeditation. He left on a mission. He said he left on a mission. So then he's texting and he said, hey, I left on a mission this morning, or he's sending the note or leaving the note saying I left on a mission this morning. Then he talks to him. He's talking about he said, yes, it was me. I'm sorry. He goes through text messages because there's more. Hold on. Let me pull up the other text messages. There's more text messages that are in the other stuff that we didn't see yesterday. Lance says, you aren't the one who did it, right? Here, I'll show you. I have it right here in my little stuff. You aren't the one. And the automatic text even tells him, drop what you're doing and look under the keyboard. That text led him to the keyboard where the note was. Okay, then Lance says, what? You're joking, right? And he says, oh, I tried to delete that. He didn't say, oh, he said F, but we're changing that out. Then he talks about how he's still okay, but he's stuck in Orem for a little while longer. He wants to come home, but he's still got to grab his rifle. What do we know was left? The rifle. We saw him, the suspect, go into the woods right there. And he says in these messages that he had to leave the rifle in a bush where he changed clothes. We know that he was changed clothes. We know that the rifle was found in the area, in that wooded area where we saw the suspect running. He says, you weren't the one who did it, right? He said, I am. I'm sorry. They said, I thought they caught the person. He said, no, they grabbed some crazy old dude, then interrogated someone in similar clothing. He had planned to grab his rifle. He's telling his plan. He's showing right here that this was premeditated. This was his plan. As if leaving the note wouldn't be enough. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. Lance says, why? He said, why did I do it? Yeah. Then he gives an answer on why he did it. I had enough of this hatred. Some hate can't be negotiated out. Then he goes back to talking about grabbing his rifle. Lance asks him, how long have you been planning this? He says, a bit over a week, I believe. Well, what was it? August 27th? Did that Turning Point USA put out I may be wrong on that date, but I think it was around August 27th where Turning Point USA put out the schedule that he was going to be at UVU. Okay, so then he says, I'm sorry for bringing you into all this. Nobody else knows up to his knowledge or according to his knowledge or whatever. He's talking about going and getting his rifle and then having to go to work. Talking about going and collecting the gun again. He's talking about the canines that were walking by the area. I wish he had circled back. He's going to be late coming home. He's just sitting in there waiting for that guy to leave so he can get his gun. He's checking the spot. The squad car moved further away. He's giving updates while he's still there, waiting, trying to hopefully get his gun. Then he talks about the actual gun. He's giving details on the gun that eventually is recovered in the exact spot that they saw him go. He says, I don't know if it had a serial number, but it wouldn't trace to me. I worry about prints. If I had to leave it in a bush where I changed outfits. Didn't have the ability to bring it with. I might have to abandon it and hope they don't find prints. How the F am I going to explain losing it to my old man? Only thing I left was the rifle wrapped in a towel. Talks about the change of clothes. He says, oh, this one was where you can only see a little bit of the end of that one. 3, and then act confused when he asked for it. I'll say I left it with him. He's planning on how he's going to explain to his father that he's not bringing home this, rare gun from his grandpa. He says it was $2,000 scope. Well, a $2,000 scope on a rifle helps you hit a shot from 138 yards away. He said he's on the way home. Delete this exchange. He says he's going to tell his boss that he got food sickness. Then there are more texts. These aren't the ones that were deleted. These aren't the ones that were shown yesterday, but this is even more stuff that they're going to show during trial. He talks about how his dad wants photos of the rifle. He's going to say, he says his grandpa wants to know who has what. And the feds released a photo of the rifle and it's very unique. He's calling me right now and I'm not answering. He's worried about it. He says, don't talk to the media. Don't take any interviews or make any comments. If police ask you questions, just get a lawyer and stay silent. He starts talking to him. He says, I'm sorry, but I think this might be it. If the way is clear, I can try and come your way to say goodbye. He's telling Lance, I'm going to come say goodbye. He asks, are there cops outside? Why are you calling the police? He says, no, not yet, but I have no doubt they will be on me within an hour. And I will be giving up my location and going in to turn myself in on my own terms. I have no intention of being drugged through the courts in front of the country. He's going to take a plea deal. Can I come see you? After that, I can call my dad and see if he's willing to help me or not. So they're making plans. Lance is at his parents'. He's making plans to come see it. He said, he's asking for any ideas. He said, for an excuse, I don't know. For getting out of this, none short of my family being willing to cover for me. I am fucked. I'm not going to be, Lance says, I'm not going to be able to leave. They come up with an excuse to get him to leave so that he can go there and see him one last time and say goodbye. He said, my coworker has just sent me the still of me on campus. What's your ETA? This is an entire text thread of him in the aftermath of all of this saying, here's a still shot of me on campus. Here's my grandpa's rifle. I did this for this reason. I've been planning this for over a week. I left you this note just in case I don't make it back. Then before he goes and turns himself in at 8 o'clock or 8:30 or whatever, he sends a Discord message that says, let's see what it said. It said, sorry, guys, whatever it was. Sorry to be the one to tell you. I had that pulled up somewhere. Where is it? Oh, here it is. He says in Discord at 7:42, right before he goes to turn himself in, hey, guys, I have bad news for you all. It was me at UVU yesterday. I'm sorry for all of this. I'm surrendering through a sheriff friend in a few moments. Thanks for all of the good times and laughs. You've all been so amazing. Thank you all for everything. Then according to the search warrant, he confesses to his dad. He has this family friend who used to be a deputy help arrange for him to turn himself in because he has confessed to his dad. He has confessed on the note. He has confessed to Discord. He has confessed to Twigs. He has confessed to everybody who's listened to him, says he's sorry, and now he needs to go turn himself in, but the DNA might not be his. I don't know of a jury who can hear all of that and think, you know what, I don't think it was him. This is not the situation where you are in an interrogation room for 6 hours and pummeled by authorities and all of this. They didn't even know his name. Didn't even know his name. He turned himself in. And then you put his DNA. Okay, they can't say his DNA was up there, but they can say that it is 1 trillion times more likely that it was him than some stranger. His DNA on the screwdriver, which was left on top of the roof, which is where the shot came from. All the texts about the bullets and like etching the bullets, all of the the DNA alone, okay, you take all of that stuff and then you take, okay, the DNA puts him on top of that roof. The DNA puts his finger on the trigger. The gun, he admits it's him in the videos. I mean, the license plate is, his plate number is got by the, officer that night when he's still trying to get his gun. I don't know And I went into this wanting to have an open mind and see everything. I don't know how a jury will be able to see all that and be like, I don't know. I get that there are wild conspiracy theories, and there are probably some conspiracy theories that make a lot of sense. I get that. I have not dug into those yet because I wanted to be tabula rasa. I wanted to come in blank slate and hear the evidence. We have not heard the defense yet, but what we have heard from the defense is not convincing at this point. But this isn't trial. That doesn't mean that they can't come out with a great defense. But at this stage, I don't see how you can explain away all of that to a jury. But what do I know? I'm not a lawyer.
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like.
No, you were right, 154. Yeah, this is one. What's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire.
Go to the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele.
Correct.
At that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found at that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele. The sequence within that 17 allele is different. So two people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Brunetter's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that?
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay out further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. And likelihood ratio numeric value is not a measurement of the physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present. Yes.
Well, it doesn't say it's possible. It says, for example, approximately in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes.
Is it possible for me to take a look at it?
Sure.
I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material. And
So could you bring up
question can be rephrased.
one, is it Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83.
Let's do a poll.
Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep going, and then at that point we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Good morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories, and additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice-a-year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this looks like report number, or exhibit number 30. If we can pull that up just for the witness. Kimberly.
It would be interesting if it does go to trial to see what the defense brings up. Because like I said, I don't know how they're going to get over all that for a jury.
Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
So we go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
Let's do another poll.
The swabs of the protected underside of the receiver of the rifle after disassembly, the swabs of one 30-06 cartridge case, the swabs of one 30-06 cartridge, and the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3. Do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
That's very damning.
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6?
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations of the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case. Is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired. Cartridge case has been fired.
All right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together. So I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yeah, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Okay.
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is that what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused? Yes. All right. Thank you, ma'am. Can we step down? Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling? And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if you.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only to the state, now my understanding there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right.
Skip to live. I love a good, strong defense case. So if this goes to trial, we'll see what they have to say. Right now they're struggling. So we'll see what they can bring. I think if it wasn't for the text messages, and they said they had the Celebrite, so it's not just the screenshots, it's like the actual Celebrite report. But I think if it wasn't for those texts and the note, the case would not be nearly as strong. I think that's the part that is going to be what a jury would hang their hat on. Weren't we told by Karen Reed, or weren't we told in Karen Reed by Celebrite experts that it's not always reliable? That's only for Jen McCabe. That's only in Canton. Because keep in mind too, any of those jury members are not going to be the people who are researching this case and going down all the rabbit holes and doing all of those things. They're going to hear the evidence that's presented. So I think pretty much any regular juror that heard all of this would vote guilty. So if this does go to trial, the defense would have to try to make all of that make sense. That's if it goes to trial. I think he'll take a plea deal. Mm-hmm. He didn't plan on getting away with this or coming out of this alive. Yeah, I think he hoped to, but based on his note, he hoped to, but he didn't know if he was going to. Any idea what exhibit 12.1 could be? So this is the video. It's like an 8-minute video of the surveillance footage that they said follows Tyler along campus on that day. They had originally tried to admit this like as an exhibit, and the defense objected because they have it like zoomed in and they have it circled and all that stuff so you can watch along easier. And the defense objected that, and they wanted it entered in as just the raw footage, like just how it comes. So that's what was entered in. So they have requested to have this played in court so that Erica Kirk and the family are able to see it. So it is being played for her. The victim's attorney yesterday requested that. I would be shocked if he didn't take a plea deal too, but we'll see. Also, because his text said he doesn't want to go through a court with the country watching. I just don't see how a regular jury is going to be able to overcome all of that evidence unless they have a very strong defense that they're ready to present. Erica Kirk is the victim representative. So she has an attorney there that's advocating for the victim representative. She's the victim representative. Is there a place to read my notes? Oh, no, I just have them. I have a spreadsheet. But I am putting all of this together in a podcast episode that will be out tomorrow morning. Hello, hello. We're just sitting here listening to the judge type. That's all. Slick. Hold on. I'm talking to my husband for a second.
All right, and that concludes the playing of Stacy Exhibit 12.1 video. Transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
I love it when they hit their little gavel. Isn't that precious? I just love that. So what are we thinking? How are we feeling? It seems like way too much time. I know it does, but I mean, I get it because they're having to do the briefings. That's the big thing, because the state's briefing is due on July 28th. So that's 35 pages of legal argument that they have to write. So their briefing is due on July 28th. The defense's response is due 2 weeks after that, so August 11th. And then the state responds to that 7 days later, which is August 18th. And then, what is it? Less than 2 weeks after that, they're doing the oral argument. So it's like they have all of these different things that have to happen, and they have to have the time in between it. But, oh gosh. But it is like adding a whole lot of extra time to our deal here. I cannot imagine what the defense is possibly going to argue on September 1st. They will argue. I mean, they're going to give it a go. You know, the thing is, they're going to have to try to, I'm going to end our poll. They're going to have to try to give it their last go about why there's not enough evidence for this to go to trial, why it should not move forward to the trial court. But honestly, they're probably going to start working on a plea deal. He's not going to want to face the death penalty. So, I don't know. We'll see. We'll see what happens. Especially because that is a lot of evidence that they have presented that a jury is not going to be able to easily overlook. Because keep in mind, too, juries are not like us where they're constantly debating over these things. Juries are not like us where they've seen, like, you know, defendants get railroaded, so they automatically question everything. Like, juries are like regular people who aren't trial watchers and aren't attorneys and aren't, you know, people who watch all of this play out every day. They're regular people. And that's something that the defense always has working against them, because regular people think that you've got, like, they're there, you know, to listen to the evidence and decide if, you know, they can prove beyond a reasonable doubt that they did it. But most people go into this thinking if there's somebody sitting in a defendant's seat, it's for a reason. If there's somebody sitting at that defense table, it's for a reason. So when you already have that as a defense, when you already have that working against you, it's an uphill battle. Now, whether that's right or wrong, I mean, obviously, like, how many times have I preached this? How many times, those of you who listen to my podcast know how many times I've said that. Like, I've always said, it should be the presumption of innocence. That's where it should be. You should start at innocent and force them, or make them force you over that threshold to where you can no longer say, you know, there's no defense for this. I can't, it has to be them. It has to be them. You should make them force you over that hump. But unfortunately, the way that we go into things, maybe not we, because we're all up in this scene, but unfortunately, the way that most people go into these situations, they're going into it automatically believing that the right person is likely on trial. That's why it takes so little evidence to convict people sometimes. And that's not how it should be. But how many times we see it happen? And this isn't just a little bit of evidence. This is a lot of evidence. And I think that's why it's going to be crucial for the defense. You can't, this is not the type of situation where you can just, in my opinion, this is just my opinion, 0 days of law school, years as a juror, 13th juror. But this is not the kind of situation where you can just pick holes at the evidence. They are going to have to, and if they're going to want to change a jury's mind or present reasonable doubt, they are going to have to give something more than just trying to pick holes in the validity of DNA. It's going to take more than that. Now, obviously, this is not the place to do that. The trial would be the place to do that. So we don't know what they have up their sleeve. We don't know what they're thinking. What they showed us so far, not great. I'm going to be honest with you, not great. But we'll see what happens during trial. That's what trials are for. Do you think Eric or Kirk will allow him to have a plea deal? Yeah, I mean, I don't know how it is in Utah, but in most jurisdictions, you know, like they will talk to the victim's family about that, but it's not a decision for the victim's family. Sometimes the victim's families, you know, are not happy about the plea deals that are offered, but that's something that is worked out between the prosecution and the defense generally. I mean, we've seen it before where the families were angry that a plea deal was offered, but let's assume it's not sufficient evidence. What was the purpose of the note, text, and turning himself in? Will they argue he wanted 15 minutes of fame? There are charges for that too. The problem is, it's not 15 minutes of fame when you wrote a note before you left because you wouldn't have known. He wouldn't have known. He wrote that note and then left and was gone the whole rest of the day. By the time he got that note, he had already been gone. There's no way he could have just done it to get 15 minutes of fame when he was gone that whole time. And the note was taken, a picture of the note was taken on Lance's phone back at their crib while Tyler Robinson was still in Orem. They normal. They ain't like us. Thank you so much for the super chat. I'm so glad you covered this and we got to watch it with you. Thanks, girl. I had a great time with y'all. It's been a long week. And now I got to work on the podcast for this, where I'll put everything together and tell it in story form for you. I honestly think if the state offered life without parole, he'd take it, and Erica would agree because he couldn't appeal for many years to come. That's my opinion. I could understand that too because, you know, especially in a death penalty case, like let's say he gets convicted, there are years and years and years of appeals and legal process and everything is drug out. Like that, a conviction and sentencing to death is not like, oh, he gone. There's a whole long, very long process. And that's how it should be. I'm not saying anything about it, but if you're going to take somebody's life, you know, then there needs to be checks and balances on that. So I'm not saying that, but it is a very long process. So life without parole, if there is a plea deal and he takes life without parole, that is going to end up being less of a legal battle in the long run. So what's the purpose of the break? So the transcripts for this hearing are going to be available, I think, next week. The state has 2 weeks from the time they get the transcripts to come up with their brief. They have 35-page limit. They can argue for 35 pages their legal reasoning for why this should go to trial, why they've met that standard. After they file that, it's due July 28th. After they file that, the defense has 2 weeks to file their response saying, you know, hold up, bro, this is not, you know, it shouldn't go to trial. And this is why, this is why, this is why. Then they have to file that by August 11th. And then once that's filed, then the prosecution gets their turn to reply to that. And that is only 18 pages, but that one's due 7 days after that on August 18th. And then September 1st is when they actually do the oral arguments. And then the judge makes his decision. I think it's a pretty easy decision, obviously. He went into the wooded area. He dropped the gun there, not like dropped, but like hid it under a bush, like wrapped in a towel, and was planning to go back and get it according to his text messages. And then he could not get back to the area to get his, because he had parked his car in the neighborhood over by campus. Like, so he went through the wooded area to that neighborhood, but then he couldn't get to his car. How do I make sure I don't miss future live streams? I had no idea you were covering this until I randomly logged on. Turn on your notifications. I think I'm going to look. I'm not sure which the next one we'll be doing is. I really want to do Courtney Clenny, and that one starts next month, but I don't know if we're going to be doing any between now and then. I'll take a look. There are people who say they text the family and have those texts saying Tyler never confessed to his parents and that they spoke with them at the court and they say he never confessed. And that's not even something that they admitted into this. That was just something in the search warrant that he confessed to his parents, or I think it was his dad specifically is what the search warrant said. So they didn't present that during this. I'm pretty sure, I don't remember hearing it if they did. And I took notes on everything. But that wasn't used in this. So we'll see if it does go to trial, if they use that or not, but. I thought Tyler Robinson had a heated conversation. So that was somebody else. The guy with the bullhorn and everything, that was somebody else. And he was actually on the suspect list pretty early on because of that. But, I mean, I guess he kind of looked similar. They're both kind of like thin, you know, brunette, young dudes. I'm sorry, all the thin brunette young dudes look the same to me. All kids look the same to me now because I'm old. So, like anybody that's like under 30, I'm like, they're all the same. But he was like on the suspect list in the beginning because of heated argument, but he was cleared pretty quickly. That one agent said that when he got the call that somebody was turning themselves in, it was the first he had heard of Tyler Robinson. First time he heard his name. Now, I don't know if that's what he said. I don't know if that's the first time all of them had, because remember, they ran his license plate, or at least wrote down. I don't know if they ran it. They wrote down his license plate when he was coming back that night, trying to get his gun. Assuming the judge agrees to have a trial, any idea when it might be scheduled to begin? It will probably be a while because it is a death penalty case. I could be wrong, 0 days of law school, but just based on what we've seen, those generally take a little bit longer, and it's a little bit because they're more involved. Is Clinty really good? That's the plan. We'll see. We'll see. Who knows? Will all your live streams be back on your 13 Juror channel, or will some be on the Crime Junkie Jury channel? I'll probably still do both. I have to figure out which ones I'm going to do on which ones. This one was so last minute because I wasn't sure if I was going to be able to cover it. So I didn't have time to plan accordingly to work it out for that one, but I'll be doing both. All right. That wraps it up for today. I appreciate y'all coming and hanging out. Lucy was looking right at the camera and it was really cute. And then I put her on there and then all of a sudden she's like, I'm just going to lick myself instead. All right. I appreciate y'all hanging out. Thank you for the super chat. Y'all are the best. I appreciate it so much. This has been quite a week. I am going to get to work on the podcast episode so that I can get it done and recorded tonight, and it will be released tomorrow. If you have not listened to the court report episode yet, listen to that. Let me know what you think. And if there's any other big stories that you want me to cover in any of the episodes of court report, feel free to let me know. Oh, yes. And make sure to hit the like button on your way out. All right. I appreciate y'all. I'm going to take me a little break before I start on the podcast. So I appreciate y'all. Thank you so much. It has been quite a week. Look at us being back here together as jurors. Look at us go. I appreciate y'all. I will see you very, very soon. And next year, no, not next year. Take two. Let's try that again. Next week, I might do court report here. I'll release it as a podcast episode too. But I might do that one live. I might start doing that one live. Or if I can't do it live, at least do a video of it. So we'll see. We'll see how it goes. All right. I love you so much. I will see y'all all very soon.
I gotta go. I can't stick around here forever.
It was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?